evening, everybody. It's my great privilege to welcome you to the very first Soli Sorabjee Memorial Lecture and the Excellence Awards which will follow. I welcome Justice Nageswara Rao of the Honorable Supreme Court, who will be our keynote speaker today. I welcome Justice Gawai of the Supreme Court, the judges of the Delhi High Court, Mr. Brian Speers, President of the Commonwealth Lawyers Association, Professor Raj Kumar of Jindal Law School, who has really organized our program today, Madhavi Divan, Additional Solicitor General of India, a member of the family, Mr. Jehangir Sorabjee, and Mr. Satvik Varma, advocate. Mr. Soli Sorabjee was a mentor and guide to all of us. That was his primary value in our lives. He mentored me, he mentored so many lawyers like me. And this mentorship went way beyond the law. Of course, the law was an important part of the mentorship. Whenever we sat with him, precision and being to the point was the main thing that he emphasized. After you have rambled on for a little, an impatient question would be put to us. What is the proposition? Formulate it. It's something that we are losing track of nowadays. We often go on in a diatribe, not quite focusing on the proposition, the point, the legal point, the point in which you can put across to the court. It is a conceptual approach to the law which sometimes today we fail to follow, as a result of which things sometimes ramble on for hours and days. A short issue becomes a long one. You know so many things about the lawyer, Mr. Sorabjee, the man, Mr. Sorabjee, and his love for music. He was part of almost all the international organizations which flourished in Delhi or still flourishes in Delhi. The Commonwealth Lawyers Association was one of those who he mentored into being almost in this country. When Mr. Santanam Krishnan held the first conference here in Hyderabad some years back, Mr. Sorabjee was really the guiding force behind that conference. And look where we have come today in this organization. The topic of the day, as you can see, the role of the Supreme Court of India in augmenting the scope of fundamental rights, and who better to talk about it than a judge of the Honorable Supreme Court of India, which has been described as an institution, as the sentinel qui vive of this country. That is, the institution charged with watching over the rights of its citizens. With that, I would like to invite Brian Speers, the president of this organization, to give his address. Thank you.
Thank you for those opening remarks. As has been said, my name is Brian Speers and I'm the president of the Commonwealth Lawyers Association. Now, I've met as many of you as I have been able to, and some have even guessed where my accent is from, but to put those who can't quite place it, I am from Belfast in Northern Ireland, and it's been my great privilege and honour to be leading the Commonwealth Lawyers Association since our last conference in Zambia in 2019. We did have a conference in the Bahamas in September of last year, smaller of course because of the travel problems caused by the pandemic. And you will have seen on your way in, and you will certainly, I hope, pick up on your way out, if you haven't already done so, some information about our next conference, which will be in lovely Goa in India this time next year. It's a great pleasure to be here and take part in the inaugural memorial lecture for Soli Sorabjee. I was greatly privileged to enjoy a lunch with Mrs. Sorabjee and her two sons, and we thank Ranjiv Malhothram, who is present for the generosity of that lunch earlier. Indeed, one of the Sorabjee family, one of his sons, is going to speak during the course of these proceedings. I think that there are many of the attributes of Soli, who was a life president of the Commonwealth Lawyers Association, which are to be found in an excellently warm but playful article found in today's India Express, where the author suggests that Soli would have been thrilled that I travelled from Belfast to be here. The reality is that I am thrilled to be here, and I'm thrilled that there's such a marvellous opportunity to take part in this really significant event with so many wonderful colleagues that I hope to meet during the rest of my stay. So thank you all for coming. Thank those who are listening on the wonders of Zoom for zooming in. And thanks to my immediate predecessor, Santan Krishnan, for all the work he has done in chivying you to come along today, in promoting the event, and in making this the success with such a distinguished gathering that is here today. Can I also thank Rahul and his brother and the other students for their assistance in manning the reception desk, and to the Jindal Global University Vice Chancellor for your collaboration, because there's a very important award to be made later on in these proceedings. It is a mark of the reach beyond India that Soli had, that colleagues from across the Commonwealth joined together last year in a webinar to bring some reflections of their fond memories of encounters with Soli. Indeed, we assembled 12 past presidents of the CLA to share in a webinar, and they got up early in Canada and they got up very late in New Zealand to bring memories of their encounters with Soli, either at the Commonwealth Law Council meetings or at Commonwealth Law conferences. And indeed, some reflections from those conferences were shared over the lunch we had today. I know that many of you will wish to investigate the Commonwealth Lawyers Association, will wish indeed to be tempted to some of the other events beyond the conference in Goa this time next year. And there are two events that there are also particulars about awaiting on the table, and some of you will have picked those up. One of them is an event in my home city of Belfast on mediation. And I know that the Supreme Court Mediators Association is really leading the world, I would say, on its promotion of mediation, its thoughtful reflections on how lawyers can be problem solvers rather than problem creators. And I would have thought that Soli would quite like the idea of lawyers as the solvers of problems, with a gentle encouragement here or a nudge there. We will have problems quietened rather than inflamed. The Commonwealth Games are taking place in Birmingham later this year, and in the shadow of the Games there will be another legal conference in Birmingham, and I hope that some who fancy a trip to the UK might fancy a trip to a legal conference and maybe take in the Games as well. It's a great privilege to sit next to Justice Rao. He and I shared a platform in the Law Society of Singapore when travel was permitted, and we both spoke at a really lovely event there on mediation, and I still recall some of your remarks then, Judge, and I'm absolutely sure that I'll be making notes as you address us in a short while. And thank you very much for coming along and speaking today. So to bring my remarks to a conclusion, I simply say thank you for coming, thank you for listening on the Zoom, and thanks to everybody who has made this event already memorable, and we look forward to the keynote remarks that are coming up very soon. If I could just borrow shamelessly from the said article in the India Express today, where Soli was spoken of as having a cosmopolitan global outreach. And I think that's true. You may think of him as a son of India, but actually he was a son of the Commonwealth, and his global influence across the Commonwealth regions was second to none. And we hope that this memorial lecture suitably honours his memory. Thank you for your attendance, and thank you for coming.
May I have the privilege now of inviting Honourable Mr. Justice L. Nageswara Rao, a judge of the Honourable Supreme Court of India, to deliver the Soli J. Sorabjee Inaugural Memorial Lecture.
Mr. Brian Speers, President, Commonwealth Lawyers Association. Ms. Madhavi Divan, Additional Solicitor General of India. Mr. Jaideep Gupta, Senior Advocate, Supreme Court of India. Dr. C. Raj Kumar, Vice Chancellor of the Jindal Global University. Satvik Varma, Senior Advocate to the High Court of Delhi. My dear friend and colleague, Justice Gawai. The President of the Bar Association, Mr. Vikas Singh. The family members of Soli Sorabjee. Advocates, ladies and gentlemen, and others who have joined this meeting through Zoom. It's a rare honor for me to deliver this first memorial lecture, which has been instituted by the Commonwealth Lawyers Association, which is a fitting tribute to a legendary figure in law. Today is his 93rd birthday, and we are meeting at a center which was his second home. He used to be here almost every day except on Sundays, and most of the dinners he gave were in the same hall. The last time when all of us met him for his birthday celebration was also in the same hall. Soli Sorabjee was Attorney General for a period of 2 years. We all grew up adoring him, and my acquaintance with him grew into a stronger bond when I was appointed as an Additional Solicitor General in 2003 when he was an Attorney General. He groomed me, he nurtured me, he also encouraged me. He was a great leader is what I found to start with. Immediately after I was appointed, there was no chamber for me because of shortage of space. He had to go on a tour for a week, and then he said, you start functioning from here. So I started off working as an ASG, being the junior most from the Attorney General's chamber. And thereafter, he used to continuously ask all the law officers as to what are the cases that they're interested in. And he used to overlook the distribution of cases. He used to take immense interest in the work that was being done by his colleagues and their difficulties. A number of advocates who were with him in his office have grown to become the best lawyers in the country. And one of them is a colleague of mine, Justice Lalit. He had a knack of picking up talent, encouraging them. As a person, he was very affectionate. And as some of the senior advocates who are present here do, it became a habit for us to visit London during summer. And for a month in June, he used to stay in an apartment in Mayfair. And for the past 15 years, almost every year, I used to go there for a week or two, and then almost on a daily basis, we used to meet either for lunch or for dinner. In 2009, when the Commonwealth Lawyers Conference was held in Hyderabad, he was the guiding force, as Jaideep Gupta was mentioning. I was there in the team. The entire work was done by Mr. Santan Krishnan. And the conference was a major success. We had a large number of lawyers coming from all over the world. And we had the President of India, Prime Minister of India, and the Chief Justice of India attend that conference. He took a lot of interest in the activities of the Commonwealth Lawyers Association. Whenever it was possible, he used to participate in their conferences, but due to the restriction in his mobility, he stopped participating in the conferences in the later years. He was a champion of fundamental rights, and his contribution to the march of law is immeasurable. He was interested in enhancing the scope of fundamental rights and protection of fundamental rights to the citizen of this country, not only through arguing cases in court. He used to write regularly. Even in Indian Express, there used to be a column of Soli Sorabjee. And most of his articles were about the fundamental rights and the decisions of court. He was fearless, as and when the court was going wrong, he used to point out that there is an error that is committed by the court. The number of cases that he argued which have a bearing on enhancing the scope of fundamental rights are large in number. In this country, Constitution is suprema lex. That's a paramount law of the land. And in the words of Soli, rule of law runs like a golden thread in the Indian Constitution. The vision and goals of the Constitution are set out in the preamble. And these goals are to be carried out through the fundamental rights and directive principles of state policy. Article 14, Article 19, and Article 21, they form the golden triangle which stand for equality and rule of law. What are these fundamental rights? Most of you who are sitting here need not be given an introduction, but we have a large number of people who have joined us through Zoom, I think most of the Commonwealth law countries. These are the basic human rights which have not been invented by the Constitution. They were already there. These are all the natural rights of a human being. which are only guaranteed by the Constitution of India by being put in Part 3 of the Constitution. These are rights which are transcendental, primordial, or inalienable. These are the phrases that have been used by the Supreme Court while referring to the importance of fundamental rights. And these are the rights which are essential for attainment of full intellectual, moral, and spiritual status. These rights impose negative obligations on the state's power of encroaching on individual liberty. And mind you that these rights are not absolute, and there can be restrictions that can be placed on these rights. The preamble, being the forerunner of the Constitution, speaks of we the people of India giving to ourselves this Constitution, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity of integrity of the nation. I will deal only with the golden triangle of Article 14, 19, and 21 and speak about how the Supreme Court was instrumental in augmenting the scope of these rights. It will be not possible for me to go into anything further except dealing with these three fundamental rights in view of the 30 minutes time that has been given to me to speak. Article 14 is in two parts. It protects the rights of persons insofar as equality before law is concerned, and the second aspect is equal protection of laws. Equality before law is that no one is above law, and every person, whatever his rank or condition, is subject to the jurisdiction of ordinary courts. The Supreme Court has been reminding the citizenry of this country about what Thomas Fuller has said, "Be ye never so high, the law is above you." This is what we would find in a number of judgments that are given by the Supreme Court. All equals are to be treated alike, and inequality would be an antithesis to discrimination. There cannot be any person who can claim any privilege in favor of that person, saying that I should be treated differently. Equality before law is synonymous with formal equality. We're talking of equality amongst equals. This is a principle which we have taken from UK when the Constitution was made. And the second part of Article 14, which is the equal protection of laws, is what we borrowed from the American Constitution. This second part also flows from the first part, which is the concept of equality before law. This implies application of laws alike and without discrimination to all persons who are similarly situated. We are in the largest democracy in the world. We have 29 states. There are 121 languages. There are 270 mother tongues. There are hundreds of castes, different religions. In spite of all this country is doing so well only because we believe in unity in diversity. The government has a duty to ensure that social, economic, as well as political justice is given to all citizens of this country as provided in the Directive Principles of State Policy. How is it that all persons coming from various backgrounds, various hues, and where the disparity in this country is so large? You have 70% of the national income within 10% of the populace of this country. And the gap between the haves and have-nots is so wide. For the purpose of ensuring that persons who are not equal with the others are given opportunities for the purpose of bringing them up, the principle that has to be followed is providing them certain benefits, providing them with some concessions, and this is codified in the principle of substantive equality. The principle of substantive equality, which is being promoted by the Supreme Court, takes into account the different conditions and circumstances which stand in the way of equal access to enjoyment of basic rights of claims. When we talk of inequality, we can speak of social inequality. In this country, the history has shown that there has been discrimination in respect of a large number of people on the basis of caste, on the basis of religion, on the basis of tribes, on the basis of sex, and even on the basis of place of residence and domicile. Access to be given to resources is to be provided as a part of distributive justice by the government, as contemplated in the Directive Principles of State Policy. For the purpose of providing access to resources, the principle of equality has to be seen in light of substantive equality. A person who is not being given access to resources cannot complain of discrimination because there are persons who require this to be given. And that is the reason why substantive equality is the principle which has been promoted by the Supreme Court. Another duty that is cast on the government is to provide economic equality, to also find a solution to the economic disparities of the people. It is incumbent on the state to treat certain persons who do not have the same resources like some other persons in this country. The principle of substantive equality comes into play. This is where the question of reservations in providing certain admissions to educational institutions and reservations in public employment comes in. There are persons who do not have access to these resources, who are being provided facilities for the purpose of lifting their lot and to bring them on par with the others, to ensure that the principle of equality is in their favor. Article 14, as was interpreted by the Constitution initially, was on the basis of a reasonable classification test. When you start discriminating people, when the government makes laws favoring a group of people, and that action of the government is challenged before a court, that this classification should not have been made and everybody is equal, all of us should be considered at par. The court initially applied the classification test. Classification of a particular group of people from the rest of the people was tested on these two principles. One, whether there is intelligible differentia in the classification, and two, whether there was a nexus of this intelligible differentia to the object that was sought to be achieved. And any classification was found to be unreasonable if these two tests were not satisfied. Later, the Supreme Court has brought in arbitrariness as a ground for challenging executive action as being violative of the principle of equality. In a judgment delivered by the Supreme Court in 1974, I'm avoiding giving the names of cases, as I told you, because of the international audience might not be able to follow all that. In a case decided by the Supreme Court, it was said that arbitrariness is antithetic to equality. It is a sworn enemy of equality. And equality was declared to be a dynamic concept which cannot be cribbed and cabined within the confines of doctrinaire limits. It was said that any action which is arbitrary is hit by Article 14. This was the expansive meaning that was given to Article 14, and any action which was tested on the annual of Article 14, any action which is arbitrary can be set aside. Later, this principle of arbitrariness has been applied to even judicial review of legislation. There is a difference between judicial review of administrative action and judicial review of legislation. In this country, when a legislation is challenged, it is challenged only on two grounds. One, that it is not within the legislative competence of the legislature, and two, that it is violative of fundamental rights and the Constitution. All along, the principle that was followed in judicial review of legislation was that the wisdom of the legislature is not within the scope of judicial review in view of the accepted principles of separation of powers in this country. But in later years, in the last 4 or 5 years, the Supreme Court, while referring to the law laid down in the earlier judgments, has ruled that manifest arbitrariness can be a ground for judicial review of legislation also. This would be a ground which is taken for challenging a legislation with a caution that mere arbitrariness would not be a ground for a court to interfere with legislation. In any event, it is settled law that you don't attribute motives or malafidis to the state legislatures or the central legislature, and that can't be a ground for setting aside legislations. You can also not impute motives, or you cannot set aside a legislation that it suffers from extraneous reasons. But manifest arbitrariness continues to be a ground as of now for testing the validity of a legislation. I go to Article 19. Article 19 of the Constitution protects certain rights regarding freedom of speech and expression, and the other freedoms which I am not going to deal with right now. Speech has been dealt with by John Milton in the 17th century, and the importance that speech acquires for development of a human being. I quote John Milton, who said, "Though all the winds of doctrine were let loose to play upon the earth, so truth be in the field, we do injuriously by licensing and prohibiting to misdoubt her strength. Let her and falsehood grapple, whoever knew truth put to the verse in a free and open encounter." John Stuart Mill continued this philosophy by saying, if a censored opinion contains truth, its silencing is damaging, as it lessens the probability that truth be revealed. It has been accepted that robust discussion is conducive to the discovery of truth. Speech being prohibited has been dealt with by the American Supreme Court. Initially, when there were restrictions that were placed on speech, the test that was followed by the US Supreme Court was a bad tendency test, where speech could be prohibited if it adversely affected welfare of the people. Then came Schenck in 1909, when Holmes applied the clear and present danger test. This was a case which he carried forward in his dissent in Abrams. And this is the famous case where he said that what happens if somebody in a theater shouts fire? Can he still say that his speech is protected? Later, clear and present danger test was changed into a balancing test in Dennis, where courts would balance the interests of the freedom of speech and public interest. And thereafter came Brandenburg versus Ohio, where the imminent lawlessness theory was adopted, which means that whenever there's a restriction that is placed on speech by the executive, and when somebody challenges that restriction, the government has to justify its action by showing that this speech is going to imminently cause some lawlessness. The connection cannot be remote. In a judgment that was delivered by this court, Brandenburg test was applied to Indian law, and the imminent lawlessness theory has been made applicable when restrictions are tested in court. Initially, there was a judgment of the Supreme Court of India when a newspaper in Madras was banned for carrying certain articles which were against the interest of the state and which would affect public order. In a case decided by the Supreme Court, it was held that such a restriction is not permissible. Mere apprehension of law and order being a problem could not have been a ground for interfering with the freedom of speech that is guaranteed in Article 19. Thereafter, there was an amendment to the Constitution where one of the restrictions which is permissible is public order. Unlike the US Constitution, which is open-ended, 19(2) of the Constitution of India has about 8 restrictions. The government can place restrictions on the freedom of speech only on those 8, one of which is security of state, 2 is public order, decency and morality, defamation, etc. After that judgment came, after the amendment was made to public order, there were several cases that were tried by the court which involved curtailing of free speech in this country. Those cases extended to censorships of movies, articles that were carried in newspapers, speeches that were made by politicians, etc. Without dilating too much on this topic, the latest judgment which dealt with the freedom of speech pertained to Section 66 of the Information and Technology Act. By 66A of the Information and Technology Act, a restriction was placed on offensive speech and it was made punishable. It was made punishable for a period of 3 years. There was a challenge to Section 66A on the ground that it violated Articles 14, Articles 19, as well as Article 21 of the Constitution of India. While deciding the case, the principle that was laid down was that there are three aspects of speech. One is discussion. The second is advocacy, and the third is incitement. What was said was that there's no problem with the first two aspects of discussion and advocacy. The problem would arise only when there is incitement. So the test that was being followed was, if there is something pertaining only to discussion, then you cannot say that this free speech cannot be curtailed. And even if it crosses discussion and goes into advocacy, that I exhort people to accept my viewpoint and then do whatever I am telling you, that also cannot be a ground for curtailing the freedom of speech. It's only when I incite people to commit a violence, there might be a case for it crossing a line and falling within the restrictions. There was a case that was decided by the Supreme Court earlier, where in the state of Punjab, there were people who were standing on a street corner and then shouting Khalistan Jindabad. And they were tried for seditious speech. This court said that merely because certain people are standing in the street corner and then shouting Jindabad would not incite people to do any violence. And they said that such a restriction could not be placed. We can add so many instances to how the Supreme Court has protected free speech of individuals in this country, as and when there is a comment or a criticism made by the citizens against the government. Whenever something is said against the establishment, we would see that there is a reaction by the establishment, and they would not take the criticism in the proper manner. There were a number of cases which were registered against individuals, criminal cases, on the ground that the speech resulted in sedition, that is violation of section 124A, and section 153A, which is a section in the penal code which deals with promoting hatred amongst religions and amongst the citizens of this country. This section 124A of the penal code was challenged in the Supreme Court on the ground that it violates the fundamental right of freedom of speech. This court refused to declare section 124A as unconstitutional, but it has said that every speech which is made against the government policies or against whatever government has done cannot be seditious speech. If the court has said that you have to take a view in favor of the fundamental rights and not be swayed by whatever is the opinion of the authorities about the speech being contrary to the interests of the security of the state, and it cannot be a seditious speech. And what is promoted by this court in all these judgments on fundamental right of speech is this, that every individual should be given an opportunity to openly discuss about issues. If you remember Brandeis, who said that inert people are a menace to democracy. Only through public discussion that you grow as an individual, your intellectual capacities would grow, and only with discussion that there is awareness that is spread amongst the people. And the most important aspect is the theory of marketplace of ideas, which has been propagated by Holmes and thereafter in this country. If the truth has to come out, it can be only with discussion. The truth has to grapple, as I read out, with the falsehood. And unless there is public discussion, unless there is awareness in the people about the political rights, there would not be a democracy which is worth its name. So discussion and speech are promoted by this court in several judgments which I can't go through at this stage. We come to one aspect of speech which is hate speech. Hate speech is a mischief that is committed by a few individuals to promote hatred amongst groups. This country is divided into groups. And this is not adding to the tranquility of the society. But how is it that you categorize every speech as hate speech is the question that would engage the attention of courts in matters that are coming before the court. Assuming I criticize a leader of a particular group, can that be categorized as a hate speech? Or if I'm inciting people belonging to a particular group to be up in arms against another group, that might be, but it all depends on the facts of the case. There was a case which came up before the Supreme Court where hate speech was an issue, and the court requested the Law Commission to examine as to whether there should be a provision to be made dealing with hate speech. The Law Commission went into the issue of hate speech, and it said that every speech cannot be categorized as hate speech, and hate speech, on the other hand, need not be restricted only to leading to violence. It cannot be said that only the speech that is made is going to lead to violence and a criminal case or a crime. That need not be hate speech. It can also be, hate speech can also be stopped if, even without the tendency of it turning out to be a criminal case or a criminal action, if it is driving a wedge between communities on the basis of caste, religion, divisions, and groups. But there was a proposal made by the Law Commission to introduce 153C and D, which has not been done till date. In this era of social media, hate speech is something which has to be taken note of. The other aspect which has engaged the attention of court is the action of the executive in interfering with social media, shutting down internets. A ground that is made for shutting down internet in the interests of the public and law and order, peace, has been dealt with by the courts. One instance that comes to my mind is that there were some videos that were played on the internet showing some violence in Myanmar and dubbing it to be a violence that was committed in Assam, where the Assamese were driving away people coming from the other parts of the country. And that led to a panic. And Assamese children and others who were working in the other parts of the country, almost 50,000 of them, they had to go back to their state because they were apprehensive of a backlash from the persons who are living in various parts of the country, because the news that was spread was that all outsiders were driven from Assam. This happened recently, 7-8 years back. There was an internet shutdown then. There was another internet shutdown in Kashmir, about which I won't speak because that's still a matter which is pending consideration in court. I think there were some orders passed earlier, pursuant to which the shutdown of the internet was closed. With the growing computerization and the age of internet, freedom of speech would be falling for scrutiny before the courts often and in myriad shapes. But the court has been wedded to protecting the freedom of speech, and given a chance, wherever there is a challenge, it would definitely be taken up by the Supreme Court to enhance the scope of speech. In 1605, Lord Coke in Samain's case said that every man's house is his castle, and nobody can forcibly enter into his house. Even the sheriff can't enter into his house. That is the principle of right to privacy which has been in vogue for the past 500 years. Initially, after the constitution was made, there was a writ of habeas corpus that was filed in the Supreme Court on the ground that a person who was already in detention was again detained under the preventive detention laws, and his detention was challenged on the ground that it is violative of his right to life and personal liberty, which is guaranteed by Article 21 of the Constitution of India. The majority judgment in that case held that the question of liberty can be tested on the ground of Article 21 and not on Article 19(1)(d). The point that is decided, which as lawyers we should look at, is that the object with which a legislation is made and the subject matter of the case will be looked into only on the violation of a fundamental right which is put in challenge and not the other fundamental rights. Fundamental rights were seen in individual silos and they cannot be looked into together. They're not overlapping, is what was decided. And thereafter, another case of surveillance at homes came up for consideration before the Supreme Court, where again the complaint was violation of Article 21 and Article 19. In the earlier case, what was decided was the rights of a person, insofar as Article 21 is concerned, cannot be taken away unless there is law, unless there is a procedure that has been prescribed by law. If there is no law, no. If there is some law, then it might be difficult for the court to interfere under Article 21. And even when the matter pertaining to surveillance came to court, the same principle was accepted, but for the first time in that case, the right to privacy of an individual was recognized by the court. But still, it was said that if you are challenging the detention or surveillance on one violation of a fundamental right, then the other fundamental rights need not be looked into. There was a dissent of one judge in that case, which was accepted by the later benches, and especially in one case in 1978, this court reversed that approach of the Supreme Court and said that Article 21 deals with all the all the human rights of a person, apart from whatever has been dealt with in Article 19, the freedoms that are mentioned in Article 19. And all these rights are overlapping. When state action is challenged before a court, the court has to see and the state has to justify that its action is not violative of not only Article 21, Article 19, Article 14, all the fundamental rights. So what has been decided in that case is that there is an opportunity for a person to say that don't look into the object with which the act is made or even the subject against whom the act is made, but you'll also have to see whether all my fundamental rights are intact or are violated. The other point that was decided in that case is that it is not sufficient if there is procedure established by law for the purpose of justifying action of the government in a challenge to the action of the government under Article 21A. The procedure established by law should be fair, just, and reasonable. By this process of interpretation, the procedural due process, which was initially discussed before making the Constitution and not included, came to be included by the Supreme Court. There is a criticism that due process could not have been included because it was categorically discussed on the advice that was given by Justice Frankfurter to B.N. Rao when he went to ask him about how Article 21 should be. Justice Frankfurter told him about the cases in the US Supreme Court between 1919 to 1935 and the interference of the Supreme Court in legislations which are welfare legislations on the ground of due process. So he suggested don't include this. After Rao came back, there was a discussion in the Constituent Assembly and the due process was not included. There is some sort of a dissent on this as to whether you have brought in something which was not accepted initially, but there was a discussion even in the initial judgments about the process which is to be followed by law, whether it should be by following principles of natural justice or not. Initially, the court was of the opinion that nothing can be read into the Constitution. It only says procedure established by law, so we will only follow as long as the law is there. There's no question of interfering. But by interpretation of the provision, by giving content to this right under Article 21, the Supreme Court has introduced the procedural due process, not the substantive due process, saying that the procedure that is established by law should be fair, just, and reasonable. The Supreme Court has delivered so many judgments on Article 21. The most important of them are protecting right to dignity. The human dignity of a person was protected in a judgment of Sunil Batra, which was argued by Soli, where this court frowned upon bar fetters and also degrading punishments. And thereafter came another judgment in 1981, where Justice Field's judgment in Munn versus Illinois was quoted to say that human existence is not equated to animal existence. It comes with dignity. There is a right of prisoners as well, because that case pertained to the prisoners' rights of having visitors who have come to see them. And it has been said in that judgment, which is followed thereafter, that every citizen has a right to claim that he has human dignity which has to be protected. And dignity comes from being provided with all basic facilities. That is, right to food, which has been subject matter of a judgment of the Supreme Court, and the teeming millions in this country who are not able to get 2 square meals a day have been given some food. There is a right to shelter, which has been dealt with by the court, right to livelihood, right to education, right to health. All basic needs have been dealt with by this court at one point of time or the other. Strictly speaking, all these which have been read into Article 21 are part of directive principles of state policy. And according to our constitution, directive principles of state policy are not enforceable in court of law. They cannot be challenged in a court of law. But by a progressive interpretation, the court found that when you have Article 21, which protects right to life and personal liberty of a citizen, there is a scope for providing this flesh to the bones which are already existing in Article 21. We provide the content to the right of Article 21. And then directions that were given are beneficial to a large number of destitutes and deprived people of this country. With these progressive ideas in mind, though facing a criticism of exceeding limits once in a while, the Supreme Court definitely has been augmenting the fundamental rights in this country. The Supreme Court has been true to the expression sentinel on the qui vive, and I'm sure that the fundamental rights, which are basic rights of individuals in this country, would be protected even in changing times by enhancing the scope of Part 3 of the Constitution of India. Thank you.
Thank you very much, Justice Nageswara, for that very illuminating discussion on the fundamental rights and how the Indian Supreme Court has dealt with it. May I now invite Ms. Madhavi Divan, Additional Solicitor General of India, to address us.
Justice Nageswara, Justice Gavai, Justice Narasimha, Honorable Judges of the Delhi High Court, the family of Mr. Sorabjee, Zina Auntie in particular, my friends on the dais and friends and admirers of Mr. Sorabjee. Exactly a year ago, on this very day, on the 9th of March, in this very hall, we had gathered to celebrate Soli's 92nd birthday. It was a hall really packed with people, and the air was abuzz with mirth and merriment, and many memorable speeches were made. But little did we know that barely a month from the time we were going to be hit by that avalanche of the second wave, and that swallowed up many, many precious lives. The bar is poorer, much poorer without Soli, and so is this very institution, the India International Center, which was so much a part of Soli's life. I refer to him as Soli in deference to, I think, what would have been his wishes. In the true Bombay tradition, he did not want to be addressed as Sir, or certainly not Soli J, so we will defer to that. On a personal note, my first recollection of the name, of encountering the name Soli Sorabjee, was as a teenager in my own neighborhood where I grew up in Delhi. And down the lane, at the end of the road, was a house with a big sign which said Soli Sorabjee. And I thought, what an unusual, distinctive name. I had no idea who he was. But I think there was this very unusual, alliterative lilt to his name. And that's what I mentioned back home to my parents, and they said, "Did you not know this is a legendary lawyer, one of the greatest in the country?" So that was my introduction to the name Soli Sorabjee. Of course, the law was very, very far away from my little universe back then, and I had no clue that I would ever meet the man himself, let alone in court. The measure of a great lawyer is not what he does to further his own practice, not what he does for his own career, not just the great judgments that he shores up in court, but it is what one leaves behind the example that is set for generations that follow, how he or she inspires lawyers who follow, and how the path one sets for oneself impacts the decisions of others. As a young practitioner myself in the Bombay High Court many, many years ago, I discovered how it was a path really fraught with such uncertainties. There would be a brief on one day and then a few days without any briefs, and I thought very hard. I thought hard about what I could possibly do differently to spend my time more meaningfully. And at the time, I encountered a book in my father-in-law's vast law library, and it was titled The Emergency, Censorship and the Press in India, 1975 to 77. The author was Soli Sorabjee. It made a good racy read, and it got me interested in the subject of free speech. It was perhaps one of the triggers that propelled me to cobble together my own very modest contribution to the subject of free speech. Of course, I was forewarned at the time that young practitioners who write are not likely to be successful lawyers, and successful lawyers rarely write. But of course, Mr. Sorabjee was the exception to that rule. He was a very successful lawyer who also contributed in no small measure to legal writing. One of Soli's, I would say one of his great qualities was to pursue and very passionately pursue his interests outside of the law. Years ago, he introduced me to the library committee of this very institution, the India International Center. And I remember how month after month, he would preside over these meetings, and he found a lot of time and patience for this very, very important task. He had the ability to combine erudition and industry with joie de vivre. His passion for poetry was as firm as his commitment to the law. He had the ability to engage effortlessly with people across the world in times when the world was not so globalized. I do recall that around the time that the NJAC case was being argued in the Supreme Court, and I happened to be assisting Mr. Rothke, who was then Attorney General, I happened to meet at the home of Mr. Sorabjee, the chairperson of the UK, the Appointments Commission. And I remember this very engaging discussion, and some of what I took away we tried to incorporate in the written submissions in that matter. So, he engaged with so many people with such diverse interests. It was always really fascinating there was always fascinating conversation in his home. His interests being so diverse, I think his zest for life was so enormous. And he showed how life outside of the law could enrich one's life in the law. And I think that it was his diverse interests, his passion for so much outside of the law that made him such a great lawyer. And today, on his birthday, I'm sure that Soli is in a very good place, enjoying a good glass of wine and some good jazz, some good poetry. And I would wish for him, for all time, and for that I will quote from one of his favorite poets, John Milton, who's already, of course, been quoted by Justice Rao. But this little passage is, I wish for him, a quiet, ingenious and piercing spirit, not shackled or restricted, the liberty to know, to utter and argue freely according to conscience above all liberties. Thank you very much. Thank you.
Thank you, Ms. Divan. And it's a real pleasure and pride to know that you have followed the footsteps of Mr. Sorabjee to go from being a writer of the law to a very successful lawyer. May I now come to another part of this program, a wonderful part of this program, where Professor Dr. C. Raj Kumar, Vice Chancellor of the OP Jindal Global University, will introduce to you the Soli J Sorabjee Excellence Award and Scholarship.
A very good evening to all of you. I would like to, first of all, thank and appreciate the extraordinary lecture that we just heard from Honorable Mr. Justice Nageswara, Judge Supreme Court of India. Thank you to our other distinguished guests, Mr. Brian Speers, Ms. Madhavi Divan, and of course, Dr. Jehangir Sorabjee. Thank you to Mr. Jaideep Gupta and Mr. Satvik Varma. This day is a very important day for a number of reasons, but whenever we celebrate and come to India International Center, Soli's presence reverberates this hall. So many memories, not just last year, but he was so deeply attached to this institution that all of us can recollect a Soli Sorabjee story. So I want to recollect a Soli Sorabjee story. This was way back in 1998. I had just graduated from the Campus Law Center Faculty of Law, Delhi University. And I was invited to be one of the shortlisted candidates for the Rhodes Scholarship. And Mr. Sorabjee was the chairman of the Rhodes Scholarship Selection Committee. And I had not known him before. I only heard him and seen him from distance, a very distinguished lawyer. Something that Madhavi said, we can only see from distance and admire and really appreciate his contribution. Of course, Mr. Sorabjee very quickly made us feel very comfortable, and the Rhodes has a tradition of having a dinner before the selection committee. So we had a dinner previous night, and he was chatting and making us all feel comfortable. And then, of course, the interview happened the following day. There were 20 of us who were interviewed, and each one of us were spent approximately 45 minutes to an hour. And Mr. Sorabjee, in the course of interviewing me, on 2 occasions, he of course had my CV, and on 2 occasions he mistakenly said, "How was National Law School, Bangalore?" When he asked me first time, I said, "No, sir, I went to the Campus Law Center Faculty of Delhi University." And he didn't note that. And again, almost 30 minutes into the interview, he repeated the question and said, "How was Bangalore as a city to live?" And at that time, I became a little bit impatient and restless. And I said, "Mr. Chairman, I had already told you that I did not go to the National Law School, Bangalore, but I studied at the Campus Law Center." And of course, the interview ended, and I was reflecting about the way my tone and tenor of that response. And of course, later that evening, Rhodes announced it, and Mrs. Sorabjee announced along with the 12 other members. And I did get the Rhodes Scholarship. And so I got introduced to this man with an extraordinary sense of humility, simplicity, and of course, honesty and rectitude. For those of you who are watching this program from different parts of the world as a part of the Commonwealth Lawyers Association, I want to quickly identify 5 phenomenal and inspiring attributes of this human being. One, of course, many of us spoke about it, his commitment to the rule of law. A lot of us know about what he did in India, but very few people know about his significant contribution to international rule of law through his work in the UN Office of the High Commissioner of Human Rights. He served as special rapporteur on a number of areas. He was prepared to, assume responsibilities despite a very busy career in law, and he would travel around the world, essentially speaking truth to power, and that was something he was so conscious of. Second is that his deep and abiding faith in institutions at a time when institutions are suffering from significant degree of decay. He had enormous faith in these institutions, including the institution that he was part of, which is the judiciary and the legal profession. Now, this faith in institutions came from his personal commitment to values such as honesty, integrity, and rectitude, but also a deep sense of civility, gracefulness, and dignity, which was all pervasive in his public and private engagements. Third, his strong commitment to the advancement of the cause of access to justice in all forms and manifestations. In fact, this is an area Soli significantly spearheaded, working closely with academics, public interest lawyers, clinical programs across law schools, and of course, other like-minded individuals in the legal profession, including lawyers and judges. Fourth, his very conscious commitment to being a mentor across multiple individuals, including a generation of lawyers who have worked with him. Every other lawyer who has had the opportunity to be mentored by Soli would tell you how much painstaking efforts he had taken to ensure that his mentoring had some meaning and purpose. And the fifth is a strong sense of interest that transcended law. Madhavi talked about jazz and poetry and, of course, many other aspects of his life. So I want to conclude this part of my reflections by saying that not only Soli Sorabjee raised the hope that we have in the legal profession, but he was a beacon of hope all through his career, even in his last days. And he was never a quitter, and he continued to inspire all of us. So it's a great tribute that all of us have gathered today to celebrate his life and contribution. Let me quickly go to this special occasion as a part of this lecture. I am very delighted to announce the Soli Sorabjee Excellence Award and Scholarship that we have instituted at Jindal Global Law School of OP Jindal Global University. There are broadly 5 significant reasons for it. One is the obvious one, celebrating the legacy of Soli Sorabjee, a man of all seasons, somebody whose legacy ought to be remembered forever. Second, marking the occasion through the celebration of an individual scholarship to a young law student who hopefully will become again a beacon of hope and contribute to the key areas in which Sorabjee made his contribution. Third, fulfilling the vision of Soli Sorabjee by creating an endowment with an award of an excellence award for a student who has done outstandingly well in the subject of human rights and contributed to development of scholarship, and I'll come back to it in a minute. Fourth, the endowment also reflects the perpetual commitment of our institution to the legacy of Soli Sorabjee. I am grateful to Mr. Satvik Varma, a distinguished lawyer, a graduate of Harvard Law School, a senior advocate in the Supreme Court of India, for his personal commitment and dedication to supporting this particular act of philanthropy, which will in many ways perpetuate and indeed celebrate the legacy of Soli Sorabjee. Lastly, also it is to inspire many other lawyers and other individuals in different walks of life to come forward to ensure that this contribution of Soli Sorabjee doesn't remain only in the books of history, but also it becomes a living memory and lived experience for all of us. With those words, I'm going to invite Mr. Karthik Agarwal, a student of Jindal Global Law School, who has secured the highest marks and received distinction in the subject of human rights. And I'm going to request Honorable Mr. Justice Nageswara Rao, Judge of the Supreme Court of India, to award the Soli Sorabjee Excellence Award and Scholarship to Mr. Agarwal. Congratulations, Mr. Karthik Agarwal, and thank you, Honorable Justice Rao, for that. Now it is my pleasure to invite Dr. Jehangir Sorabjee, son of Mr. Soli Sorabjee, to share some reflections on the life and contribution of Soli.
I have just a few brief remarks. So, first of all, as a doctor, I can tell you that I'm been afflicted this evening with something called Imposter Syndrome. And that is a syndrome which occurs when you stand up before an audience and think that you have no reason to be there. And you're a fraud in that sense, which I think I am here. But really, on behalf of the Sorabjee family, I want to thank everyone, especially Justice Nageswara Rao, Brian Speers, all the other distinguished speakers, and all the distinguished members of the audience for their really kind remarks and going out of their way to give such excellent lectures and speeches, which will hopefully serve as an inspiration to everybody. I think the one thing that all of us as a family realized when Dad passed away was how overwhelmed we felt with the spontaneous outpouring of so much praise and affection that came from all walks of life, which frankly we were not aware of. Suddenly, as a doctor, I was assaulted by names like Satwant Singh, S.R. Bomai, Maneka Gandhi, Bhopal Gas, Shreya Singhal. Who are all these people? Dad had never mentioned them to me ever. And in fact, my father wore his achievements so lightly that only recently I discovered that he had stood first in English in his matriculation exams in the entire Bombay presidency. And I had no idea about that until somebody slipped me a newspaper cutting from 1946, actually describing that. The one thing about Dad was that he absolutely loved law, and he loved every aspect of it. He loved the rough and tumble of arguments, the rush, going to court late, so that there was always that last-minute tension which drove him, which drove us mad in the process. He loved the academics, the intellectual discussion. He enjoyed the writing, the conferences. He enjoyed interacting with lawyers in social life. And I think he particularly enjoyed harassing Satvik a lot in the last few months by ringing him up every 3 days in the lockdown saying, "I'm lonely, come and see me now, come and see me now." And Satvik has been extremely kind, especially with this award as well. So we I've personally sort of realized that he was much more a figure than we accounted for in our day-to-day family life. In July, I had the unpleasant task of actually emptying out his home and returning it to the landlady. And I had to go from room to room and clear out everything from more than 25 or 30 years that he'd been living there. And I knew there would be nothing of value. Dad had no attachment to anything which was sort of commercially valuable. And I was absolutely right. I was chuckling, and when I told my family members, there was not one thing, not one watch, not one work of art, nothing, absolutely nothing, which was of any particular value. And that was not a surprise to me. But there were books. And my God, there were books. And there were books, and there were books, and there were books. And we were so lucky that Professor Raj Kumar and many others were kind enough to accept the books as part and parcel of their library. And then I thought again to myself that in an abstract way, that was actually his wealth. The wealth that he had was the intellect, which was in those books which he studied. The intellect from the diverse different fields that he went into that translated itself into his own intellect, with which he seems to have made an indelible, an eternal mark on jurisprudence and the rule of law and the Constitution of India. And that was wealth which I think none of us as his children would be able to equal. So I'm going to end with a little 2 lines from a poem in deference to Brian. It's an Irish poet, a Nobel Prize winner, Seamus Heaney, who writes, "Where does the spirit live? Inside or outside? In things remembered, in made things, or things unmade?" And I think that's where my father's spirit is. It's both inside the law and outside the law. It's in things that we remember about him, in laws made and laws unmade. Thank you very much.
Thank you very much, Dr. Sorabjee, for those reflections. We are indeed coming to the end of this program. I have great pleasure in inviting Mr. Satvik Varma, Senior Advocate, Supreme Court of India, to deliver his concluding remarks.
Thanks, Raj. We've had a long evening. I promise I'm not going to... I heard what Jaideep had to say. I'm not going to ramble on at all. So in just a couple of minutes, but I do want to... and before I thank the honorable judges in the room, I want to just correct Raj on one point, or rather supplement Raj on one point, that Mr. Sorabjee had more than 5 attributes. He had a 6th one too, which is his love for sugar, which he was prohibited by his doctor son from having. And therefore, in his memory on his birthday, we have one of his favorite cakes. And I would request that before you all leave, you must partake in a piece of something that Dr. Sorabjee prohibited his father from having. The last comment was about spirit. In my remembrance note for Mr. Sorabjee, I wrote that his favorite spirit, many of you in this room would have had the pleasure of having it with him, was Old Pa, a rare spirit, and it was a reflection of the rare personality that Mr. Sorabjee was. I'm slightly overwhelmed today, and I'm overwhelmed because while I got frequent calls from Mr. Sorabjee, I was a beneficiary of being his neighbor, rather my parents, who lived 2 doors next to him. And he would often call me and say, Baba, kya kar rahe ho? Aajo. And for the international audience, that was a call at about 8 o'clock saying, what are you doing? Come by. And I used to be his excuse for that 6th point, which is to eat his Shrewsbury cookies that Auntie Zina had sent, but they were sort of in lock and key. But I didn't get to say bye to him. And that was one of my deepest regrets, that here's a man that I was seeing every week, and I didn't get to say bye. And while it's very tough to keep the memory alive of a person like Mr. Sorabjee, it's yet so simple, because he actually liked, as Jehangir said, only the simple things. And nothing would have given him greater joy than to have this room full on his birthday. So I, from the sort of bottom of my heart, thank you all for coming. I'm extremely thankful to the family. Auntie is flown in from Bombay. Jehangir is here. Hormaz is here. He's kind of hidden under a tire usually, not brought out that much, but that's Mr. Sorabjee's son. Thank you, Justice Rao, for that riveting lecture. I don't think we could have had a better start to the Soli J. Sorabjee Memorial Lecture. Thank you, Madhavi. I think Mr. Sorabjee would have been delighted that you were one of the speakers today. He was, as you know well, very fond of you and held you in very high regard. Thank you, Brian, and your team. I can see Claire, Bridget. Thank you. And I think we do owe a lot of gratitude to Advocate Santanam Krishnan, the immediate past president, who's hiding at the back, but who more than just collaborating with letting us collaborate with him, also made Auntie Zina's job easy, because she would be torn. So when I called her and said, I've reached out to Santanam and he's going to collaborate, she says, oh, great. So thank you, Santanam. Thank you, Raj. Thank you for carrying forward the legacy. The initial Excellence Award in Scholarship is for 20 years. And Karthik, you will always bear the title of being a recipient of the first Soli J. Sorabjee Excellence Award in Scholarship. So do it justice. And it's just so you know, it's in the field of human rights, a topic that was very, very dear to Mr. Sorabjee's heart. And it sort of, it's just, it's overwhelming. It's making me emotional. I just want to thank Justice Gavai, Justice Narsimha. We have Justice Sanghi, Justice Bambani, Justice Pratibha M. Singh, Justice Pratik Jalan. We have former Judge Justice Mita here. We have Madam Shrisha. All of you have taken out time on a weekday to be here. Thank you. I'd request Auntie Zina to cut that cake so we can all partake and indulge in something that Mr. Sorabjee would have wanted us to do on the 9th of March. So thank you all for coming, and please do not leave without having a piece of that cake. Thank you.